You've decided to start your business and make it official. You search your business name on your state's Secretary of State website. Eureka, it's available. You go ahead and file your LLC registration, get your EIN, open your bank account, and start building your business around that name. What you don't know is that someone in the next state over is not only operating under the same name in the same industry as you, but they've also gone ahead and obtained a federal trademark registration for it. Under federal law, that business has the ability to prevent you from operating your business under your name. And you won't realize it until you get that scary cease and desist letter in the mail demanding you change your name, take down your signs, and maybe part ways with part of your profits as well. This isn't just a cautionary tale. It happens regularly, and it happens because many business owners assume that a state registration and a federal trademark are doing the same job. They aren't. Today, we're breaking down the business name registration, federal trademark, and domain name, what each one of those registrations does, where they overlap, and what rights you have with each. I'm Jasmine Hurley. Welcome to Main Street Counsel. Now, before we get too far into this, let's start by understanding what each of these registrations are and what they do for you. Business name registration. When you form a business in your state, you register your name with the state Secretary of State. That name becomes your legal business entity name. What does that registration do? Well, it prevents another business in your state from registering the exact same entity name. And that's it. It does not give you exclusive rights to use that name anywhere else. It does not protect your brand. It does not stop someone else from operating a business under a similar name anywhere else in the world or from registering a website using your name. Think of it like staking a flag, but that flag can only be seen in your state and nowhere else. Trademark. Now, if you saw our video about identifying the different types of IP in your business, you'll remember that a trademark protects identifiers that distinguish your goods or services in the marketplace. The core function is to tell consumers the source of the goods and services. If you need a refresher, you can check out that video here. When you register a trademark, you're telling the federal government, this name or logo is mine. I'm using it in commerce, and I want exclusive rights to it nationally. Once that registration is granted, no one else can use a confusingly similar mark for similar goods or services anywhere in the country. Now, certain trademark rights do also exist without federal registration under what's called common law or even state law, but those trademark rights are limited in scope, usually to the geographic area in which you've been operating. A federal registration gives you the broadest, strongest, and most consistently enforceable protection. Federal trademark protection lasts as long as you continue using the mark and maintain that registration. They're renewable. They're critical. They're the legal foundation for protecting your brand. Domain name. A domain name is your web address. It's the URL people type to find your website. Owning a domain name means you've purchased the right to use that specific URL from a domain registrar, typically for a fee paid annually. And that's all. Your domain name is not a trademark, and it's not a business registration. So registering yourcompanyname.com gives you the right to use that web address, but not any other legal rights to the name itself in commerce. Someone else could register the same name as a trademark or as a business entity in a different state, and you'd have no legal basis to stop them based solely on your domain registration. Owning a domain is a practical business necessity. It is not a substitute for legal brand protection. But what if you do own the name as your business entity name or a trademark? Well, there's a federal law called the Anti-cybersquatting Consumer Protection Act, the ACPA, that gives trademark holders legal tools when someone registers a domain identical or confusingly similar to their mark in bad faith. Now, that covers cybersquatting, where someone parks your brand name hoping to sell it back to you, and gripe sites, where someone registers your name to post attacks about your business. Now, the key word is bad faith. Someone still has the right to voice their opinion about you or to criticize you. But when someone has no legitimate claim to the name, is using it to harm your goodwill and subsequently profit off that harm, or has tried to extort you by jacking up the price of your potential domain, courts have found that crosses the line. When bad faith is established, the ACPA can get you back the domain and statutory damages, even if that registrant is hiding behind a privacy proxy. Again, the catch: this only works if you have a federal trademark right to the name. State business registration or common law trademark does not give you ACPA standing. Now, what does that mean in the real world? The best way to understand how these elements work together and what they do or don't do is to look at what happens when real businesses get it wrong. Sambuck's coffee. In 2000, a woman named Sambuck opened a small coffee shop in Astoria, Oregon. She called it Sambuck's, after herself. It was a tiny shop serving a small town and was not by any stretch a threat to a global coffee chain. Well, Starbucks heard about her, sent her a cease and desist in 2002. They even offered her money to help defray the cost of rebranding. She ignored it. Starbucks then sued her for trademark infringement, and in 2005, a federal judge ruled against her. She had willfully infringed on Starbucks' trademark and diluted the brand. Fun fact: if you willfully infringe, courts will award triple the damages. She had to pull the name off of everything and spend money rebranding, on top of dealing with hundreds of thousands of dollars of legal fees. The lesson here is not that Starbucks will come for you, because they will. The lesson is that trademark rights are enforceable, even against someone who genuinely didn't mean to infringe initially, even when the size difference is absurd, even when the name is your own. Starbucks had the trademark and the legal foundation to use it. Chloe's Giant Cookies and Chloe's Cookies. Another more recent example is the ongoing case of Chloe's Giant Cookies. In early 2026, a baker named Chloe Sexton went viral, not just for what looked like amazing stuffed cookies, but because she received a cease and desist letter from a Florida company called Chloe's Cookies LLC, demanding she stop using Chloe's Giant Cookies. Now that stings. Miss Sexton is operating a real business. She has millions of TikTok followers. She just announced she was going to appear on a Gordon Ramsay show. She's shipping cookies nationwide. And her first name is actually Chloe. But none of that matters in a trademark dispute. What matters is who has the registration and priority. The Florida company filed for their trademark in 2018 and received it in 2023. Miss Sexton's business started in Tennessee in 2024. Now, her post went viral, millions of views, sales poured in, but that doesn't change how trademark law works, unfortunately. The courts don't look at your follower count. Again, they're looking at who filed first, what the mark covers, and whether consumers are likely to be confused. Here's hoping that the two parties are currently negotiating a way to coexist in the marketplace. Now, if you're the small business owner in that scenario, most of you watching may be, you want to be the one with the registration, not the one scrambling to defend against it or having your entire world turned upside down. PETA versus Doughney. Now, let's flip that scenario. What happens when the trademark holder does everything right and then someone tries to use their name against them online? In 1995, a man named Michael Doughney registered the domain PETA.org, identical to the registered trademark for People for the Ethical Treatment of Animals, aka PETA, and used it to host a parody site called People Eating Tasty Animals. The site linked to businesses selling meat and leather goods, undermining PETA's brand and mission. When PETA tried to engage with him, Doughney was like, "Make me an offer," just to get the domain back. Well, PETA sued under the ACPA. The court found that Doughney had acted in bad faith. He had no legitimate claim to the name. The domain was identical to a federally registered mark. The site was causing confusion and economic harm, and his offer to sell made his intent clear. The court ordered the domain transferred to PETA. Lucas Nursery and Landscaping versus Grosse. In Lucas Nursery and Landscaping versus Grosse, a dissatisfied customer registered lucasnursery.com and then used it to post complaints about the company's work. Lucas Nursery sent a cease and desist. Ms. Grosse took the site down and then put it back up when she found out they didn't have a registered trademark. The nursery sued Ms. Grosse under the ACPA and lost. The Sixth Circuit said there was no bad faith. She wasn't diverting customers for money. She was just an unhappy customer telling her story. And the court made it clear that the ACPA is not designed to stop First Amendment rights. Now, the ACPA is not a set fix. When someone has registered your trademark as a domain specifically to harm your brand or extort money from you, a federal trademark registration is a legal foundation that lets you fight back. So 4 different situations, 4 different outcomes. None of them turn on the same thing, and that's the point. Each of the registrations, the business name, the trademark, the domain name, has a specific job. And when you understand what each one does and doesn't do, you can then build your protection strategy on that. So, what do we do with all of this? What is the so what? What can you practically do as a business owner to avoid these situations? First, register your business entity and understand what you actually have. The business registration creates your legal business structure and reserves your entity name in your state. It is the starting line, not the finish line, when it comes to protecting your brand. Secure your domain before you go public. Register your domain before you announce your business. Get the .com, .net, .biz, .org. Consider common variations. Domain names are relatively inexpensive compared to the cost of not having the one you need. And if you see your domain name of choice is unavailable, investigate. That might be a signal the name is registered as a business in another state. Pursue federal trademark registration if your brand has value. If your business name, logo, or slogan represents something you've invested in building or something you're planning to build a business around, a federal trademark provides the only nationwide legal protection available to you. The process takes time, and that's why you want to start making moves now before it's too late. Remember your rights and enforce them. If you hold a trademark and someone is using it as their own mark or in a domain to cause harm, you have rights under federal law to protect you. And that's a conversation you should definitely be having with an attorney if that's the situation you're in. Now, brand protection is one of those things that feels like, again, a future problem until it's a pressing present one. So we're not just talking about this in one video, but a whole series of videos. Make sure you like, subscribe, and ring the bell to be alerted when we post those weekly videos. I'm Jasmine Hurley. Thanks for stopping by.